name is Claire McGuigan.
And mine's Deirdre O'Reilly.
And in this short presentation, we intend to outline the main issues which we have identified in this scenario, and to suggest the likely outcomes of any actions taken by the parties in this hypothetical. The first issue arising from the facts of the case is that MG may have exerted undue influence on each side when they signed their contract via email. Case law, such as John v. James, suggests that should this be the case, this contract will be struck down. However, certain limiting factors, such as the fact that each side have already had some success, should also be considered. The second issue which arises concerns the validity of the electronic signature on the contract. Under the Electronic Commerce Act 2000, this is a perfectly valid form of contracting, and therefore we feel that it poses no significant problem for either party. The exclusion clause contained in the email sent from MG to Eastside confirming the Fest Holly gig is the third issue which arises. It is our belief that this exclusion clause was not incorporated correctly into the contract, either by signature, by notice, or through a previous course of dealings, and hence it cannot be said to effectively limit MG's liability in this case.
Hearn and Matchroom Boxing Limited versus Collins poses a strong case for the argument that MG's failure to correctly organise the Berlin concerts resulted in a serious breach of their obligations to achieve the best financial outcome for their clients, and so constitutes a fundamental breach in the contract between MG and Eastside. In contract law, damages are designed to put the plaintiff, as far as money can do it, in the same financial situation as if the contract had been performed. Eastside's claims for expectation loss and reliance loss will stem from this quote from Robinson versus Harman. MG may claim, however, that the fault lies with Concertmania, and this will depend on the terms of the contract between MG and Concertmania. If MG were to seek subsequent compensation from Concertmania, this would also depend upon whose responsibility it was to ensure the venue is free. If it was Concertmania's responsibility, then MG may have a valid claim. To conclude, if the court rules in favour of a case of undue influence or fundamental breach, then the claims of Eastside and MG will be moot. MG's claims against Concertmania, however, since they are based on another contract, may still stand, but are conditional upon the terms of the contract as outlined above. If a case for undue influence or fundamental breach is not accepted by the courts, then Eastside will surely face liability for breaching their contract with MG. MG would most certainly be granted an injunction against Celebs or Us, restraining them from acting in any way for the band, since they induced Eastside to breach their contract with MG. MG may also face liability for failing to organise the concert correctly. Concertmania may also face liability from MG for their part in the non-occurrence of the Berlin concerts. Oh, my neck. Out of the word.